Almost 6 months ago now, when I first commented on the Blake Lively and Justin Baldoni case, I stated that based on previous experience, attempting to litigate a case in the media is very risky business indeed. Not just for the lawyers, but for the clients being represented by them. A very famous example of this is the Johnny Depp versus Amber Heard defamation case. When I first started covering that case, when I first started my YouTube career in 2020, I was not a fan of Adam Waldman, one of Johnny's lawyers, tweeting and giving interviews about the case, because my concern was that he was giving the other side ammunition, content, evidence to use against Johnny Depp. Fast forward to 2 years later, when the infamous trial took place in Virginia, guess what happened? Amber Heard countersued for defamation based on Adam Waldman's public statements. And because he was found to have been acting as Johnny's agent, Johnny Depp was the one who was found liable. When I first started covering the Blake Lively and Justin Baldoni case earlier in the year, I was concerned as I was starting to see a similar pattern from Justin Baldoni's lawyer and also from Blake Lively's lawyers. And I did warn that this could end up backfiring. And now it looks like it has. Earlier this month, Taylor Swift was issued a subpoena from Justin Baldoni's legal team. Now, she wasn't happy about it, naturally, claiming that she had nothing to do with the movie other than licensing the song, and therefore she has nothing to do with the case. Her team essentially accused Justin Baldoni's side of attempting to generate a media storm through clickbait. Now, I'd beg to differ with Taylor in terms of her involvement with the case, because it doesn't start and end with someone's involvement with the movie. She had a personal relationship, a friendship, a very close one with Blake Lively. I believe she's her children's godmother. And so to want to look at certain communications between the two of them does make sense. Now, in addition to Taylor's public statement distancing herself from the case and questioning the subpoena, her lawyers are trying to get rid of it. They called it an abuse of discovery process that is meant to distract from the case, along the same lines of Taylor's statement. This is just designed for clickbait purposes. So what the subpoena asked for, which was issued on the 29th of April, was all communications between Taylor and Blake, including her husband, Ryan Reynolds, and the couple's attorney. So Taylor's lawyers are arguing, well, you could have just received these communications from Ryan and Blake, seeing as communication works two ways, they have the messages too. Now, for some reason, unbeknownst to me, I'm probably missing a piece here. Last week, on the 14th of May, Brian Friedman, Justin Baldoni's lawyer, wrote a letter to Judge Lehman regarding this subpoena. And it was from this letter that I learned that Taylor's subpoena wasn't even within the jurisdiction of New York. It's in relation to an action in the District of Columbia. And so this Judge Lehman, has no authority or jurisdiction over that subpoena and any related legal action in that district particularly. And yet, Mr. Friedman wrote this letter explaining to Judge Lehman, who I repeat has nothing to do with the District of Columbia, why the subpoena shouldn't be quashed, why it is relevant. He writes, the subpoena aims to obtain discovery relating to witness tampering and evidence spoliation. Specifically, the Wayfarer parties' counsel are informed and believe, based on information from a source who was highly likely to have reliable information, that 1. Miss Lively requested that Taylor Swift delete their text messages. 2. Blake's lawyer contacted a Venable attorney who represents Miss Swift and demanded that Miss Swift release a statement of support for Blake, intimating that if Miss Swift refused to do so, private text messages of a personal nature in Miss Lively's possession would be released. So there's the blackmail component. The Wayfarer parties' counsel are further informed and believe that a representative of Miss Swift addressed these inappropriate and apparently extortionate threats in at least one written communication transmitted to Mr. Gottlieb. It is those communications that the Wayfarer parties seek to obtain by way of subpoena, as they would evidence an attempt to intimidate and coerce a percipient witness in this litigation. Blake's team then issue their own letter to Judge Lehman, calling this improper and merely attempting to stoke the fires by once again litigating the case in the media, putting in inflammatory, unsupported, unsubstantiated allegations against their client for clickbait purposes and to generate an uproar. They asked the judge to strike the letter, stating that it was not filed with any evidentiary support of any kind, much less anything under oath, and it falsely accuses Ms. Lively and her counsel of engaging in, quote, witness tampering and evidence spoliation based on an undisclosed anonymous source. I'm going to stop here because I want to make it very clear, bearing in mind, I'm an Australian lawyer. I know people from the Johnny Depp days, people, the haters used to love using that line against me. Oh, but you're an Australian lawyer. What do you know, right? Putting in unnamed sources, whether it's in a sworn statement or otherwise, is a big no-no. If you have a source, if you have someone who has evidence, you have them come forth and they submit an affidavit. I would have thought he knew better. And if you're wondering why, it's because of the rules of evidence. They're very strict. Not only are unnamed sources incredibly suspicious and problematic in the sense that you can't verify what was said, the allegations are based on hearsay, something which is mentioned by Blake's lawyers, and rightly so. Her lawyers go on to explain why this letter is improper. They state it does not seek any form of relief, is irrelevant to any motion currently pending before the court, and serves no legitimate purpose. It is not useful to the court in any respect. Ms. Lively filed a letter to which the Friedman letter purports to respond as a courtesy to inform the court about motion to quash proceedings that Venable commenced in another federal court and to preserve her own right to object. So that's why Brian Friedman wrote the letter. See, I'm learning as I go as well. It makes more sense now. That's the missing piece. However, Blake did not ask the court to take any action, and her letter did not merit or warrant any response, let alone one that purports to manufacture a conspiracy theory in order to obtain communications from opposing counsel via a third party. The apparent intent of the Friedman letter is to launder scandalous and defamatory allegations about Ms. Lively into the press by abusing the court's docket. Within minutes of the Friedman letter appearing in the court's docket, media outlets began publishing stories concerning the letter, including one that posted a 40-plus article that asserted as a fact that Ms. Lively, quote, threatened to expose Taylor Swift's private texts unless she publicly sided with her in Justin Baldoni feud. They then remind the court that during a hearing on February 3rd of this year, 2025, this court explained to the parties that it would intervene if it turns out that this ends up being litigated in the press in a way that would prejudice the opportunity of the parties to a fair trial. As such, they asked for the court to strike the letter from the docket to avoid exactly the result it presaged at the initial hearing. And finally, before we get to my opinions and explaining certain things that people have asked me to clarify, we have Brian Friedman's affidavit. So he doubled down after writing this letter to the court and went, all right, well, if you want something under oath, I'll give it to you. So he went ahead and supplied his own affidavit in which he effectively repeats exactly what he wrote in the letter, but with more detail. So he explains on Valentine's Day this year, he received a voicemail from a person very closely linked to Taylor Swift. Out of respect for the individual in question, I am not identifying them at this time. However, should the court direct me to do so, I will comply. All right. I just wish he wouldn't have put an anonymous source in an affidavit because, as I said, at least the way I was trained, that's really not a good look, especially coming from a lawyer. You expect these things to come from clients who don't know any better, but then you also expect the lawyer taking down the affidavit or the statement to advise them, hey, look, anonymous sources, they're just not going to get accepted. You know, it's your duty to advise your client about that, let alone seeing this come from a lawyer. That's why I'm surprised. He then explains that during this phone call, the speaker told me that they had informed, so this is already hearsay upon hearsay, that J. Douglas Baldridge, counsel for Taylor Swift and a partner at Venable, had received a phone call from Michael Gottlieb, again, more hearsay, this is really starting to layer up, conveying the blackmail, basically. That anonymous individual also told Mr. Friedman that they had been informed that 4 or 5 months earlier, Miss Lively had requested that Miss Swift delete her text messages. Again, hearsay. I was connected to this individual through a mutual friend, another unnamed source, who informed me that the individual wanted to talk. And then he explains, as a result of this call, I issued a subpoena to Taylor Swift's lawyers. So to me as a lawyer, I am quite surprised at the quality of this affidavit, in the sense that it's coming from a seasoned lawyer and there is more than one anonymous source and layers of hearsay. In case you don't know what hearsay is, it's out of court statements that are being introduced to prove that something is true. So somebody told me that Blake did this, and it is usually inadmissible because it is so weak you can't verify it unless certain exceptions apply, which we actually covered throughout the years on this channel, but currently are way beyond the scope of this video. Suffice it to say that this is not good, and Judge Lehman didn't think so either. On the 15th of May, which was the same day that the affidavit was submitted, Judge Lehman responded to Blake Lively's move to strike the letter, and that motion was granted. Now, a lot of people have asked me, how is this irrelevant? How has it been stricken? How have Blake Lively's team been successfully able to argue that the subpoena is not relevant to the case? Well, the answer lies within what I told you earlier. The District of Columbia is beyond the jurisdiction of Judge Lehman, who is presiding over the case in New York. And Judge Lehman explains this in his order. He says, quote, "The letter is improper and must be stricken. It is irrelevant to any issue before this court and does not request any action from this court. It concerns a subpoena proceeding in the District of Columbia over which this court has no authority." And this is the really scathing part coming from Judge Lehman, and what I have warned of at the beginning of the year if the parties persisted to attempt to litigate this in the media. The judge says, "The sole purpose of the letter is to promote public scandal by advancing inflammatory accusations on information and belief against Lively and her counsel. It transparently invites a press uproar by suggesting that Lively and her counsel attempted to extort a well-known celebrity. Retaining the letter on the docket would be of no use to the court and would allow the court's docket to serve as a reservoir of libelous statements for press consumption." The same is true for the Wayfarer party's subsequent submission, which the court will strike for the same reasons, and that would be the affidavit. We know this because when you look at the header of the affidavit, its document number is 219-1, and the subsequent submission in the court's order is noted as document number 219. But it doesn't even end there. The judge ends the order by stating that counsel is advised that future misuse of the court's docket may be met with sanctions. And yesterday, on the 19th of May, on Monday, Blake Lively brought a motion for such a sanction. Now, this sanction is not just limited to the letter and the affidavit that Brian Friedman submitted, but it's also in relation to not amending the pleadings and removing all the parties apart from Justin Baldoni from the contractual allegations, the breach of implied contract, interference, because that's in relation to Justin's contract with WME, which was terminated, but none of the other parties, including Melissa Nathan, Jennifer Abel, and Steve Sarowitz, were impacted by that contract. In fact, they were not even parties to that contract. And so Blake's arguing because they have failed to remove these parties from these specific causes of action, she wants them to be sanctioned both financially and also a reprimand, a public official reprimand against the lawyers. So I'm not claiming to know better. It's easy for us to sit here uninvolved, not under pressure, and to see things clearly. But it's difficult sometimes, even for a seasoned lawyer, to not be impacted by the pressure and to not be tempted to get into the sparring competition in the media. I get that. But personally, my style is keep your cards close to your chest and keep your eye on the prize, keep your head down, stay in your lane, and do what's best for your client. Speaking to the press is never what's best for your client, other than a cursory statement of defeat or success at the conclusion of a case. But normally, no comment is the best comment. We already saw how comments backfired for Johnny Depp, and now we're seeing the possibility, assuming this motion for a sanction is granted, for things to backfire on Brian Friedman's clients. So hopefully this will be some kind of a wake-up call for both sides. I'm not saying one side here is worse than the other, but for both sides to just stop trying to litigate this in the press. Stop making statements and responding to each other tit for tat. It's quite frankly childish, and it does no one any favors. So I hope I clear things up. People were really confused about the irrelevance of the subpoena. Again, it all came down to jurisdiction, and the whole anonymous source thing with layers and layers of hearsay, really, it has no place in a lawyer's affidavit. I mean, it normally shouldn't have a place in anyone's affidavit, let alone a lawyer's. That doesn't mean I'm siding with Blake Lively now. I know I'm gonna get that accusation because when I was covering the Johnny Depp and Amber Heard case, when I would say things such as, well, Amber Heard's team was right to argue this, which happened very rarely, mind you, I would get bombarded with accusations of, oh wow, now you're flipping sides? I thought you were pro Johnny Depp. No, I was and always will be pro truth and pro justice. Not a fan of Justin, not a fan of Blake. Whenever a side messes up and people ask me to comment on it or to analyze it or to explain it, I'm just gonna be honest about it and remain as impartial as possible. I hope you appreciate that. It's not gonna change. I'm nobody's fangirl, and I think I'm gonna end it there. So let me know if you have any other questions that I could answer, and I'll see you next time. Bye-bye.